Good afternoon, everyone, and welcome to the OKT webinar, Revenue Sharing, What Happens After the IBA. So thank you very much for your interest in this topic. And I wanted to say hi to our live audience, wherever you are, as well as to those of you who are watching the recording. So I'll just say a quick few housekeeping items about how audience interaction is going to work. So you have two options. Number one is you can type your question in the chat. Or your other option is that you could raise your hand, the Zoom hand, not your physical hand. And our producer will unmute you. And if you, I think they'll also ask if you want to appear by video as well. It'll turn on your camera and you'll be able to speak. So just say a few words of introduction. So OKT is a law firm based in Toronto and Yellowknife, and we work only for Indigenous nations. We've grown from 3 lawyers starting in the year 2000 to about 60 lawyers now. And we only work for Indigenous nations. We don't work for proponents, so you know that our advice is not conflicted. We have been in this business for 25 years. I myself, I am a litigator. That means I'm a court lawyer. And I started my career going to court to advocate for Indigenous rights under Canadian law. In the past 5 to 10 years, I've found that a lot more of my work is revolving around protecting the rights of nations that have entered business deals, especially impacts and benefits agreements, or IBAs. And that's what we're here to talk to you about this afternoon. I'll let my colleague Nick Kennedy introduce himself as well.
Hi, everyone. Thank you for joining. My name is Nick Kennedy. I've been a lawyer for about 11 years now. I started my practice at a large Bay Street law firm, worked there for close to 6 years, and switched over to OKT about 5 years ago. I've been here since then. And like Senwung, I've found over the last few years, my practice has really shifted to focus on resolving and litigating disputes under impacts and benefits agreements for our clients who've signed those agreements with government and private proponents.
Thank you, Nick. I realized I forgot to introduce myself. My name is Senwung Look. I'm a partner at OKT, and my colleague Nick is counsel at our firm. And we work closely together on a number of files involving advocating for the business interests of our Indigenous clients. So we wanted to take this opportunity to share some of what we've learned in our practice over the past number of years from our experience working with nations that are in business deals, so that we can share that knowledge so that you can be aware of some of the pitfalls that are out there about how IBAs get implemented, and be on guard so that your community is getting your fair share. So we're here to share some information, but we're not going to be giving away the confidential information of our clients. A lot of these IBAs are confidential documents, so you'll find that we'll speak in somewhat general terms and not refer to specifics. And of course, each situation is different. So what we're going to share with you is just some of our observations. It's not legal advice for your situation. If you need legal advice, please feel free to reach out to us. If you have any further questions, or if you want legal advice. And our contact information is going to be at the end of this presentation. So I'll just say a bit about our agenda today. My colleague Nick is going to talk a bit about IBAs and how did we get here. And then we're going to talk about revenue sharing under IBAs, the different kinds of revenue sharing that there are. And I'll talk a bit about some of the problems that arise. And Nick will talk a bit about some of the special problems when a business restructures. And then I'll go through some takeaways that I hope you'll find useful. And our presentation will take about 40 minutes, at the end of which we hope to open the floor and use our remaining time to address any questions that you might have. So I'll hand it over to my colleague, Nick, for now.
Thanks, Senwung. We're just going to start by laying the groundwork with a few basics that I think most people on the call will be familiar with. When we're talking about IBAs, we're talking about impacts and benefits agreements. They're agreements where an Indigenous nation consents to some kind of development in their territory in exchange for certain benefits. From the perspective of the Indigenous group, the IBA serves two purposes. One is to address the adverse impacts of development through enhanced mitigation measures that usually go above and beyond regulatory requirements, and through financial compensation for impacts. And these kinds of contractual mitigation measures are going to get more important, we think, going forward, because of things like Bill 5 here in Ontario and Bill C5 at the federal level. And number two, and this is a more recent development, is that IBAs seek to provide the Indigenous group with a fair share of the project's benefits. And that's mostly what we're going to talk about today. And from the industry side, the key benefit is certainty. Certainty that in exchange for the mitigation and the financial benefits, the community, the Indigenous group will consent to the project going ahead and potentially even support it through the regulatory process. So these agreements vary quite a bit. There are a lot of variation in the individual agreements, but they usually involve financial compensation, business and contracting opportunities, community benefits like skills building and training, enhanced environmental measures, and lastly, the project support provisions. And these agreements have come a long way in the last few decades. I mean, when I talked to people in our office about some of the earlier IBAs they saw, they were primarily in Fort Mac related to oil sands development, and the agreement would provide for the consent to the project to go ahead in exchange for pretty small benefits, like elder centers and playgrounds being built in the communities. So the benefit package was nothing compared to what they often are today. And then from there, they kind of moved to annual fixed payments, largely as compensation for impacts. And today we see far more moving from that to sharing in the benefits of the project. So revenue, profit sharing, et cetera. So lots of issues to be resolved still, but in the last few decades, they've come a long way. And now it's gone to the point where in some contexts, development is very hard to undertake without an IBA. So here in Ontario, it can be very hard for a miner to secure financing unless there's already an IBA in place. And an IBA makes a project held by a junior miner much more attractive to a senior miner because that certainty is in place. In places where you have modern treaties, some development can't go ahead at all until an IBA is concluded. So for example, in Nunavut in Northern Labrador, where there are treaties in place, certain areas you can't do anything as a developer without first signing an IBA with the treaty group. And then in some sectors, it's become government policy to promote First Nation participation. So here in Ontario, for example, Hydro One has a model where transmission lines with a capital value of over $100 million, they have a policy for securing up to 50% of First Nation equity participation in those lines. So there's a lot more to be said, but that's sort of an overview of the landscape as we see it today. And the next slide, we're just going to quickly summarize sort of what we see as sort of the three main types of revenue sharing under IBAs. I mean, these are general categories, by no means the only ways. And these are the revenue sharing side. So this is in addition to fixed payments that may be payable as compensation for impacts on rights. So the first one is sharing of gross revenues. The Indigenous group takes a percentage of the total revenue proponent brings in from project. So 5% of gross sales, for example, as opposed to 5% of profits. So this is revenue before deductions for taxes, operating costs, or financing costs. And this can, securing this kind of arrangement means that, for example, a group can continue to receive benefits from a project, even if the project is not profitable. The next one is sharing of net revenues or profits, however that gets defined in the IBA. It's revenues minus usually a series of defined expenses. And this is a lot more common than, or at least from what we've seen, a lot more common than sharing gross revenues. And it's important to remember that IBAs can incorporate very bespoke, novel ways to calculate net profits. I mean, it all depends on the specific project and a specific cost the developer needs to deduct in calculating its profits. So, for example, if you see projects funded by public money, there may be different kinds of deductions than if the project is financed solely by private lenders or by the private sector. And the last is sharing as an equity partner. So this is typically when Indigenous group takes an equity stake, shareholding, for example, in the company that owns and operates the project in question. And typically the revenue share, whether it's gross revenues, net revenues, or dividends as an equity partner, is going to be set out every year in some kind of annual statement. And the details of that statement will usually be set out in the IBA. What has to be in there will be prescribed in the IBA. And that'll explain how the annual revenue share has been calculated. So it's a very important document that we'll talk about a bit more later.
Thank you, Nick. So what I am going to do now is to go through each of those types of sharing and talk about some of the typical problems that arise. So I'll start with the first one that Nick went through, which is the sharing of gross revenues. So the idea behind this kind of revenue sharing is that it's just a flat percentage of all the revenue that is coming in into the business. That's the subject of the IBA. So a percentage of that revenue gets shared with the community. So the advantage of this kind of sharing is that it's simpler because you don't have to calculate the profit. You don't have to calculate the right expenses to include in the calculation of profit. But even though it's simpler, issues can still arise. So first and foremost, you'll want to make sure that all the revenue that should be being included in the business to be shared is actually being counted. So how does it typically work where some of that money is not properly counted? One example would be where a proponent establishes a subsidiary corporation to run the project. So let's say there's a parent company, they start a subsidiary, and the subsidiary runs the project and is the company that enters the IBA with your community. So the IBA would say, well, it's the revenue of the subsidiary corporation that's being shared with your community. So what we want to make sure is that the right amount of money that's coming out of that company is being included as revenue of the subsidiary. What we want to make sure is not happening is that the parent company is somehow making money off the project and that this money is being kept off the books of the subsidiary. And what happens in that instance is, well, if the money is somehow going to the parent instead of the subsidiary, then it's not being shared with your community. So this is something to keep in mind as you look at the revenues that are coming in through your annual statement. Are you seeing everything there that you think you should be seeing? Or are they taking some revenues and attributing them somewhere else with the result that they don't get shared? Another kind of situation is if there are related companies to the company that's on the other side of the deal. So take as an example, this parent company owns a subsidiary and the subsidiary is involved in the IBA with you. Is that subsidiary selling the product coming out of your land to a related company at a below market price? If they're doing that, then there's less revenue going into the company than there should be. And as a result, less revenue to be shared with your community. There are accounting principles that should be applied to most of these calculations, and you'll want to make sure that those principles are actually being applied. And that's, one of the things that we've seen is it's important to have an accountant look at what's coming in from the company and work with your lawyers to make sure that the provisions of the IBA are being followed. So, the accountant will look at the numbers and we'll talk to the lawyers and say, is the way that this is being calculated aligned with how you read the agreement? So that's the kind of question that you'll want your accountants and lawyers being attentive to as they look at the financial statements coming in from your IBA partners. And if the company is not following what it says in the IBA or not following fair accounting principles, then each of these, then it could be a breach of the IBA and you should consider raising the issue with the proponent. So the next set of situations is profit sharing. And we're putting profit in quotes because profit is one of the things that's potentially hard to calculate. So at a most basic level, profit is just revenues minus expenses. But profit sharing is only going to be fair to your community where the calculation of both the revenues and the expenses is fairly calculated. So what I've said about revenue sharing also applies here. So all of the monkeying around that can be done about revenues going into the company, those are also issues that can arise when you're calculating revenue for the purposes of profit sharing. So I won't go over those again since we already worked through those in the prior section. But on top of that issue is whether expenses are being fairly calculated. So the IBA itself will often have rules about which costs can count as fair expenses for the purposes of profit sharing. And of course, the more expenses that count, the less profit there is to share and the less money goes into your community. So what you'll want to do is to make sure that all of those rules, the rules that are set out in the IBA, as well as fair accounting rules, are being followed in how the company is calculating their expenses. So take as an example, if there's an IBA for a mine that's in your territory, if that company decides to spend money exploring for a future mine, are those expenses fairly calculated as expenses of that project? And if they're not, and they're being put on the books of the mine that you do have an IBA for, then your community is getting less money as a result. Another set of issues that can be tricky is financing costs. So take as an example, the proponent borrowed money to get the project started long before they entered the IBA with you. Now, those startup costs, they might put those costs into the business and as a loan and start counting the interest expenses of that loan as as an expense of the business. So one question will be, is it fair to count that as an expense of the business and reduce the profit sharing under your IBA if that loan was taken out long before your IBA was signed? It may be worth looking into your IBA to consider that question because it may be reducing the amount of money that's being shared with your community. So one last scenario that I want to talk through is it can be potentially tricky where the proponent is one of several related companies. So take the example that I went through with revenue. If there's a parent company that owns a subsidiary that's in the IBA with your community, and it has certain affiliates as well that work on related projects. One question you'll want to make sure of is whether their expenses charged to the company that you're in the IBA with that are really expenses for work that belongs to an affiliated company or the parent company. These are the kinds of questions that you'll want to review as you look through these financial statements and work with your legal counsel and with your accounting experts to try to understand the financial picture that your IBA partner is putting in front of you. So I'll let Nick talk about the equity partner scenarios at this point.
Just give it a second for the slide to come up.
Uh-oh, that went too far. Back one.
Yeah. Thanks, Senwung. So as an equity interest holder, your community would participate in the profits of a project in the same way as any other shareholder when the corporation pays out dividends. And dividends are the share of the corporate profits that get distributed to shareholders. And they're often paid out quarterly or annually as a fixed amount per share, $5 per share per quarter, for example. It all depends, though, on the specific arrangement. And it's just important to remember that as shareholders, you typically come last in the line of corporate payments. I mean, lenders, suppliers, and other creditors of the corporation get paid out first, typically before there are profits left to distribute to the shareholders as dividends. And because the share of revenues that your communities receive in these kinds of agreements come from dividends, the issues we often see are around when and how and whether dividends are actually declared by the corporation. Typically, it's the board of directors who are solely responsible for declaring dividends, and their decision to do so is based on typically the profitability of the company and the overall health and whether it's prudent in the context to pay out the profits to the shareholders rather than keep them in the company. And so the first situation you might run into is that the company and the project are profitable, but it's not paying out, the company is not paying out dividends at all. All of the profits, all the money left over after the various expenses are paid is being kept inside the corporation. So as a result, your community may not be getting their fair share of the revenues from the project. The money is staying in the company. And then it becomes a question of whether there are good reasons for that, or whether it's being done for improper or imprudent reasons. And so, for example, you could imagine a situation where the project developer is profiting off the project while your community is being left out. So, for example, if employees of the project developer are working on the project or working for the project company, a specific company incorporated to build and own the project, they're working for the project company, but they're being paid inflated above market salaries. So the situation could be that a developer incorporates a project company, the indigenous group, your community gets a stake in that company, the developer assigns a bunch of his employees to work at the project company, and those employees get paid inflated salaries. So the money that would otherwise be distributed as dividends gets siphoned off to pay these inflated salaries. So the developer is benefiting, but your community is not getting your fair share. Another potential situation is where the developer, which probably ultimately controls the project company just because they'll own a larger share of it, causes the project company to enter into contracts with related companies. So, for example, if you've bought a stake in a transmission line and the developer of the transmission line contracts to a transportation company that they also own, and those contracts are at inflated above fair market value, some or all the profits might get siphoned off to pay for that contract, which again is overvalued. So the developer is benefiting, but your community is not getting your fair share. And one last potential example is where money is being kept in the company, but then it's being used for different projects. So a company that owns multiple mines keeps profits from the mine for which you have the IBA inside the company, and then uses that money to explore for a different mine in a different area where you don't have an IBA. So money that should have been paid out as dividends to your communities is being used for a different purpose, and you're not getting your share. So these are some of the kinds of issues you can run into when your payments are based on having an equity stake. And there are ways to deal with this. If your community owns shares in the corporation, you can exercise your shareholders' rights to participate in the affairs of the corporation. You can vote at the AGM, you can vote on directors, you can demand access to financial information. And there's also remedies you can seek in court. There are corporate law remedies called the oppression claim and the derivative action you can pursue in court in order to protect your interests inside in the corporation. Another situation we run into is the effect of corporate restructuring on community revenue sharing from projects. I mean, corporate restructurings and changes of ownership, I mean, they're a fact of life. They happen all the time, but they can create all kinds of problems when it comes to the performance of the obligations under an IBA, specifically the performance of the party that's promised to share their revenues with you. And so there's just endless kinds of situations you can encounter because the different types of corporate restructuring are endless and very complicated. But some of the more simple situations you might see are the company holding the IBA is purchased by a third party, and the purchaser just refuses to respect the IBA. For example, you sign an IBA with a junior miner that gets acquired by a larger mining company, and the larger company just refuses to respect the IBA, and there should be provisions in place in the IBA to protect for that kind of situation. But that's something we see happen. Or the company that holds the IBA does an internal reorganization. The company that holds the IBA has a bunch of subsidiaries, and they do an internal organization where they transfer the IBA to one of their subsidiaries, and maybe they transfer the IBA to a subsidiary that doesn't actually have the financial means to make your IBA payments. And so you've got the IBA held by a company that can't make the payments, and even if you sue that company, it doesn't have the money to pay out what you're owed. Also see amalgamations where different subsidiaries get amalgamated. They get merged into a single company with a different name, different corporate entity, different corporate personality, and it's unclear, or there's dispute about whether the amalgamated entity is still on the hook for the various IBA obligations. And lastly, another potential situation you can run into is if the IBA has employment and contracting guarantees, which a lot of them do, but the IBA is transferred to a subsidiary, let's say, that is different from the one that is actually building the project in question. Well, then you may have no way to enforce your contracting and employment guarantees because you have no contractual rights against the company building the project because those guarantees are held by another company that's not doing the work. So these are things that all ideally can be addressed proactively through an IBA, but as with the previous section on revenue sharing through equity of interest, there are remedies you can seek in court in case this kind of situation arises.
Thank you, Nick. So we're coming towards the end of our presentation. We wanted to leave you with some key takeaways. So first off is to be attentive to the statements that you receive. So IBAs often include a detailed calculation for how revenue sharing should work. Take those statements that are coming to you and make sure the calculation is correct. If there is a right to an audit, consider taking advantage of it to make sure that those numbers are right. And one thing to be mindful of in that kind of situation is that there's usually a deadline set out in the IBA for when you have to raise concerns with the numbers. Sometimes that's 30 days, sometimes it's 60 days, but usually it's not very long. So it's important to be able to review and spot those issues promptly. That's where it's good to have an accountant that you can rely on to look at these issues, and also to have legal counsel. So make sure that your accountants and your lawyers are talking to each other about how these IBAs should be working, and to make sure you look at the statements that come in to ensure that it actually is working the way it's supposed to. Now, if you don't have a lawyer or you want a second opinion, we're happy to offer you a free first consultation. Just to get in touch with us at the numbers that I'll put up in a second. Just to talk a bit about the situations that Nick was talking about in terms of corporate restructuring. If the company that you have an IBA with is being restructured or sold, those are times when it's very important to be very attentive to what the parent company, what the affiliated companies are doing with that company that you have the IBA with. You'll want to make sure that what they're doing is being fair to your interests and is not somehow taking money or opportunities or obligations away from you. So those are also situations where we would suggest it's very important to have legal counsel looking after your interests as those events take place. So I think I finished about 3 minutes early, which I'm sure nobody is unhappy about. So I think this is a good time for us to move to our Q&A portion of the webinar. I'm putting up the slide that's got our emails and phone numbers. Please feel free to reach out to us, especially if you've got confidential information that you don't want to be sharing in this webinar. Talking to us one-on-one is probably a better option for that kind of conversation. But at this point, I'd like to open the floor for anybody that wants to talk about the situation that you're in, or make general comments. Please either type in your question into the Zoom chat or raise your Zoom hand, and our producer will unmute you and turn on your video if you wish to appear on video as well. So the floor is open.
Hi, Nick, Senwung.
We see your
Appreciate.
hands, Dan and Norma. Our producer is working on it. Okay, go ahead, Dan.
Can you hear me okay?
Yep.
Okay, thanks for the presentation. Appreciate it. I think there is a value in some of this stuff because I think a lot of the there's a lot of, I guess, language and covenants that go into these IBAs sometimes, and I think the partnership falls stale after a while. Um, I guess that one free consult, I guess I can address more specific information, but a lot of times these partnerships, depending on the corporate structure and how long the IBA is, those partnerships, those relationships become dysfunctioning. And all of a sudden, both parties may not be able to reach their covenants or the language and stuff that had set out the original IBA. And as mines produce and they start considering high prices now, they're looking at expanding the life of the mine and stuff like that. How do you reapproach an existing IBA to make sure that it's functioning properly for both partners and both partners are actually meeting those covenants and commitments? Um, yeah, I guess I'll leave it at that one question before I ramble on.
Yeah, that's a great question, Dan. And I think it's a very common scenario because when you enter into IBAs, that's usually long before a project has shovels hitting the ground. So the way that a project turns out can be quite different, especially the economics of the project. It can change a lot over time during the course of construction. So I think in those kinds of situations, you'll want to be attentive to what the IBA itself says about changes in the sort of surrounding situations. Uh, there are often clauses in there about how those kinds of changes should get handled. And you'll also want to look at uh, potential amendment clauses. So I think those are the two sets of issues that I think would be a good place to start. Maybe my colleague Nick has some other ideas as well.
And Dan, I hear what you're saying about the relationship goes stale. I mean, we see it sometimes where there are the long-term IBAs and there are changeovers and chief of council, staffing changeovers, and a lot of institutional knowledge gets lost as the people who were responsible for negotiating the IBA or managing the IBA move on to other positions. And then people take up their roles and they don't have the same information that their predecessors have. So a lot of knowledge about the relationship and the arrangement gets lost. And the people who fill the roles just don't have the background to step into them properly. So that really speaks to the importance of continuity and often the importance of having a good outside advisor. I mean, we talked a lot about accountants. Some of our clients have the benefit of having very long-term outside advisors, so there's no turnover, and those persons are able to stay involved with the project, with the IBA, sort of from start to, finish of the project, and they ensure that, or they can help you ensure that the appropriate level of knowledge is maintained and that things don't get forgotten and things don't get left by the wayside. So that, I mean, that is something we see with some clients. Again, the benefit of having committed, long-term outside advisors who are not sort of subject to changeover in the same way that inside staff might be, and that can help to avoid a lot of those problems, and it can help to make sure that the developer you're dealing with is respecting their obligations.
Because yeah, if you look at certain parts of the
Thank you,
IBA,
Dan, for your question. Now, Norma is next. I think our producer is gonna unmute you now. Norma, you're live.
Okay, I'm just wondering, these three options when you're getting into these IBAs, it's generally the proponent that suggests which of these is the way to go, or like we can just say, no, we want, like if they offer the profit sharing and we say, no, no, like, we want the partnership or the gross. Um, revenue sharing, how does that all work?
I'll let Nick start that one.
Yeah, thanks for the question, Norma. I think it really, it kind of depends on the individual project. I mean, there are projects for which you might want to get a profit share. There are projects for which you might want to take an equity interest, and there are projects where you might want to share in gross revenues. It sort of depends on the finances and the specific situation of each project. So for example, we don't often see clients who want to take an equity interest in a mine. Mining is very risky, subject to commodity prices, all that kind of thing. So if you get your mining financing and model your revenues with gold at $5,000 an ounce or whatever it is, and then the price of gold drops to $1,000 when the mine starts producing, you don't want to be an equity holder in that mine necessarily. So it speaks to the importance of having sort of good internal and outside advisors who understand the different kinds of arrangements and can help you work through the advantages. I mean, typically in IBA negotiations, you'll be able to get your hands on pretty detailed financial information from the developer. And you'll be able to ask them, okay, like, I want to see your cash flow models. I want to see your revenue projections. I want to see your expenses, all that kind of stuff. And then with your advisors, you can sit down and sort of make a decision of, okay, in this case, we want to pursue this option. And now, the developer might just say, no, we're only prepared to do profit share, or we want you along for the ride with all the risk. So we want you to buy in as an equity interest holder. And that gets you to the negotiation stage. You have to negotiate, what can you handle? What can they handle? What can you tolerate? So again, it all, sort of typical lawyer response, but it all really depends on the specific project. But the important thing is having all the information and the knowledge, either internally or through outside advisors, to know what options you have and to push for those options.
Thank you.
Thank you, Norma. That's a great question also. Is there anyone else that wants to participate in this Q&A at this point? If you're feeling shy, you can type your question in the chat also. We'll give it another couple of minutes. There's a question about this PowerPoint. Yes, we will certainly post that. I'm looking at my producer. Where will we post it? We'll send it to all the registered participants, but we'll also post it on our website, I think. Yeah. And we have a question from Daniel.
Yes, thanks. I really appreciate the talk today. Lots of good information about IBAs. Just wondering, based on your experience, if there's any recommendations you have or kind of a pre-IBA agreements you get into. Like I've heard of some nations go with MOUs or negotiation agreements kind of thing. Just wondering, based on your experience, any recommendations there? And thank you again.
Yeah, no worries, Dan. That's also a great question. I think, usually if you can get into a process agreement about how the IBA is negotiated, I think that's usually a good thing to do. It kind of sets guardrails for the discussions with the proponent, but also, maybe just as importantly, usually provides for negotiation funding. And so that's part of the capacity funding that lets you do the due diligence you need to do for your community as you explore all the different options about how or if you want to enter into this kind of arrangement with the proponent. And it also kind of sets out potentially topics for discussion. Often there will be a provision in process agreement that the proponent is not going to go ahead with the project without your consent. So often it's very useful to get some of these basics down as guardrails to, make sure that that negotiation process is happening as it should. Anything to add, Nick?
Yeah, really on the value of getting that MOU so you can push for capacity funding. I mean, that is really critical. I mean, you should not be spending your community resources to negotiate an agreement with a proponent that wants to build a mine. If they want to build the mine, they should be required, or any kind of other development with which where your consent is required. I mean, it should be on them to put up the money to fund your capacity to participate in those negotiations. And that, some communities have the money, others don't. But that goes a long way towards hiring the accountants and outside advisors who can give you the information about which options are available to you, why you should ask for certain things, and et cetera, et cetera. So it's important to get those initial agreements in place, because that is where you secure that kind of funding.
Thank you both.
Thank you, Daniel. We have Andrea.
Hi, thank you very much for this information. Just a follow-up question about the process agreement. Is that typically completed before the closing plan is approved by the proponent, or sorry, by the government for the proponent?
A good question. Nick, do you want to take a stab at that?
So you're asking about the closure plan for a mine, like whether the MOU or process agreement with the mining proponent, whether that would be in place before the closure plan has been approved?
I think that's what my question was. Yes. So what caught my attention was you said that the process agreement that is in place before the IBA is negotiated often includes a statement that the project will not go forward without the community's support. Correct?
Yep, that is language that often appears in those
Okay.
agreements.
So my question then is, if they already have their closing plan approved and have been approved to move to the next step, then they don't necessarily need our approval to do that.
Right.
I'm
I
looking
think,
for some clarity there as how that the timing of those work.
yeah, I think there can be all sorts of different combinations of how the timing could work. I think if they have, even if they have all their permits, if they have sort of signed a contract with you that says they're not going to do it without your consent, then that's potentially something that you can enforce. So that depends on how your process agreement is worded, of course.
Okay.
But if they've said we're not doing it without your consent, then that's a recognition of your nation's jurisdiction over that project in a way that's parallel to provincial or federal jurisdiction. So, the fact that they do have these permits from province or Canada, that doesn't mean they have to do it. In fact, a lot of projects have all their permits and they're sitting there because the proponent is still thinking about whether it's worth their while to do it. So yeah, I think I think it could go any number of ways, but if they've said they're not doing it without your consent in a legally binding document, then that's something that I think would usually be an enforceable obligation.
Another thing to consider is that it just may not be in the proponent's interest to barrel through the regulatory process until they've concluded an IBA with you, because if you manage to secure in the IBA really strong environmental guarantees and mitigation measures that are sort of stronger than what's in the or different from what's in their approved closure plan, I mean, they might have to go back and amend that, which is a whole other process. So, it's seems to me like it's in the interest of the developers to get those agreements with you in place first and to proceed on that basis. And another thing to consider is financing from private lenders. I mean, as I said, I think it's hard in Ontario to get financing for a mine unless an IBA is in place. And so you may not, as a proponent, want to spend a bunch of money going through a regulatory process when you don't yet have that agreement in place with the potentially impacted First Nations.
Andrea, I think you had a follow-up.
No, mine was a follow-up to the previous question.
Okay.
Thank you.
Okay, no problem. Okay, we'll move on to Garrett.
Great. Yeah, thank you for the presentation. I actually have two questions. So I'll start with my first one. It's a bit simpler. Do you have a recommended point at which you would start IBA negotiations, either before the PEA, before the PFS, after, or before the feasibility study? I'm just kind of curious if there's like an ideal point at which you would start the negotiation.
I mean, I think at the feasibility, I mean, once again, it all depends. But I think, a feasibility study is going to give you a bit more insight into the profitability of the mine. So, I mean, I think from your perspective, the more you know, the more leverage and power you have in negotiations, right? I mean, if you know that this is going to be a highly profitable mine with a 45% return on investment, I think you have more leverage to push for a bigger share, and that information is probably only going to come later in the process. So I think it just, depends on the overall context. It depends on what kind of mines you're going ahead. It depends on what commodity prices are. It depends on the demand for, if you're talking rare earths, maybe earlier is better. It really depends on the context. But I think as a rule, the more information you have, the better off you are in your negotiations. Again, especially if you have learned that this is going to be a highly profitable venture, then it's much harder for the developer to say, oh, you're squeezing us too hard because we're not going to make that much money. Well, if you know that they're actually going to make a 45% return, then you have some room to squeeze.
I think all things being equal, the earlier the better. Because, as Nick says, you get more information and you understand what they're proposing better. But totally recognize that there's a lot of projects going on, and the capacity in many communities is not unlimited. So I think part of the calculus is whether something that's at a very early stage is worth your attention. Because there may be a lot of pies in the sky that are floating around that want to talk to you. So there's a judgment call there about how to balance those interests.
Great.
Hope that
Thank you.
answered your first question, Garrett. If not, let us know.
It does. Yeah, if it's okay, I'll ask my second one. Thank you very much. Just really curious your thoughts on Bill C5 and how that might relate to IBAs throughout the country, and any kind of high-level thoughts that you might be able to share. Yeah, just curious on your thoughts. Thank you.
I think it'll be interesting to see how they actually start using it, if they start using those powers. And I think a lot will depend on how they do it. So I think, at the end of the day, the duty to consult has not gone away, nor has UNDRIP, nor has free, prior, and informed consent. And the lenders that are providing financing for these projects may all be insisting on free, prior, and informed consent. If that's the case, then the fact that the federal government is kind of walking away from environmental jurisdiction on certain projects really leaves the opening for Indigenous jurisdiction, for you to assert that and to practice that, and to make sure that any projects that happen in your territory are following your rules. Because when Canada walks out of the jurisdictional room for environmental regulation that in many ways opens the door for your jurisdiction. So, you know, we will have to see how it goes. Obviously, there's also, you know, some kind of nightmare scenario where Canada and the banks just ride roughshod over Indigenous rights. That is also a possibility. But I think we'll have to see how all the different players in the system, including lenders, approach this kind of approach the new situation. Okay, I think that's probably all the time that we've got. Really appreciate your spending the time with us this afternoon. And as I said earlier, please feel free to reach out. Happy to chat further. You have our contact info in the PowerPoint deck. And really appreciate your taking the time.
Thank you very much, everyone.
Thank you.